everybody. Welcome. And thank you so much for joining us for this third in our series of the Dean's Democracy series on the rule of law in challenging times. My name is Evangeline Abriel, and I have the pleasure of serving as your moderator today. This is the third in our series. Last semester, we presented two panels, one on what do we mean when we use the term the rule of law, and the second on the role of non-governmental organizations, including media and faith-based organizations, in preserving the rule of law. Today, we move on to a third topic, the separation of powers and the rule of law. And the separation of powers, we all learned it in civics, and it's a critical part of democracy. It's an ancient principle. Aristotle talked about it. It was part of the Roman republics. And in the Age of Reason, in the 18th century, Montesquieu set out principles that inspired the framers of the American Constitution. And the separation of powers is a critical part of the rule of law and of democracy itself. Through its goals are to prevent tyranny, to establish stable government, to protect individual rights, and to encourage transparency in government. And it does this in multiple ways. Through the checks and balances system, no one branch of government is able to monopolize the work of any other branch, and each branch has the power to monitor and to control the conduct of other branches. Through the impartial judiciary, we have protection of individual rights. Through our independent and impartial judiciary. But the separation of powers in the United States today is strained. We have an executive that arrogates to itself authority that is not entrusted to it under the Constitution. We have a legislative branch that it seems reluctant to assert the power that the Constitution gives it. And we have a judiciary that's left increasingly that we call on increasingly to protect the individual rights. At the lower level, the federal district and circuit courts are issuing orders enjoining certain conduct of the executive. At the Supreme Court level, however, we see an increasing use of the shadow docket. That is issuance of stays of orders by lower courts without full briefing and not always with complete explanation of the reasons. So these developments are troubling to the rule of law. They can hollow out democracy from the inside, and it's dangerous as any coup, and maybe more dangerous because it's not quite as obvious. It's a gradual sort of thing. And at its worst, the executive's use of power can result in retributive actions against people who don't agree with it. So today we're talking about the separation of powers and the rule of law. And we have an illustrious panel of speakers to talk about four critical aspects, four critical phenomena that we are seeing today. First, Professor Brad Joondeph will talk about the concept of presidential immunity, particularly after the Supreme Court's decision in United States versus Trump. Then Professor Nicholas Serafin will speak on the Supreme Court's shadow docket. Professor David Sloss will talk about the Unitary executive theory, which holds that the president has authority over all actions that arise within the executive, including the termination of employees and agencies that are created by Congress. And I haven't said much about these three professors because we all know them and know how amazing they are. But I did want to take a minute to talk about our equally amazing guest speaker, Robin Tholin, an attorney with the law firm of Altshuler Berzon. Robin is a graduate of Harvard Law School, where she served as the executive editor of the Law Review, and then clerked for the Honorable Marcia Berzon on the U.S. Court of Appeals for the Ninth Circuit. At Altshuler Berzon, Robin represents unions, employees, and nonprofit organizations in a variety of matters, but perhaps most relevant for our presentation today, she represents employees of federal agencies who have been terminated by the executive. So each speaker will talk for about 10 minutes, and then we'll save time for questions. And thank you, panelists, so much for being here. And Professor Joondeph, could I get you started? Could you start us off talking about the presidential immunity?
I would be happy to. Thank you so much for the invitation. Thank you for including me on this panel. I'm honored to be here and talk about this topic at, I think, is a rather fraught moment in our country's history. So what I've been asked to talk about, as Vanjie alluded to, is presidential immunity, in particular related to the decision from what was about 18 months ago, Trump versus United States, handed down by the Supreme Court. So I will discuss that. I'm happy to elaborate and talk about other topics that are pertinent to that after, when we get into question and answer, but that's what I'll limit my presentation to. So just to be clear, the precise question in that case was about a former president's immunity from criminal prosecution for acts that occurred while the president was in office. So it didn't involve civil liability, something that had been resolved in a case in 1982, a case called Nixon versus Fitzgerald, which held that presidents are absolutely immune from civil damages actions for actions that occur in their official capacity when they're in office. It only concerned, nor did it concern whether a president could be criminally prosecuted while they are in office. The Department of Justice has long taken the position that it is violation of separation of powers to try to prosecute a president, regardless of the nature of the acts when they occurred, while the president is sitting, because doing so would be such a distraction that it would violate separation of powers principles. So this only concerned a former president, prosecution of someone who's no longer in office for actions that they took while they were president of the United States. And the question was whether they have immunity from such prosecutions. And the Supreme Court held, as I'm sure most of you are aware, that such individuals enjoy a great deal, although not absolute or complete immunity from any act that occurs while they are in office. And there are two really important distinctions that the court drew that didn't come from nowhere. They were in various decisions that had existed before and precedent, but there are two really important distinctions to understand in terms of understanding the scope of what the Supreme Court held. So the first distinction, which is really important, is between official acts and unofficial acts. And the Supreme Court held that with respect to unofficial acts, acts that do not emanate from the president acting pursuant to an authority that pertains to the office itself, acting as president of the United States, there is no immunity whatsoever. Now, that might be a vanishingly slim category of acts that a person takes while they are president of the United States, because almost everything they do is related to being president of the United States. But we can at least imagine some set of circumstances in which the president is acting unofficially. And for those acts, the president enjoys no liability from criminal prosecution once the president leaves office. So imagine the president sneaks off, jumps in a car, unbeknownst to the Secret Service, hits someone in a car. Those sorts of acts would not be immune from criminal liability. But again, it's got to be a vanishingly small, slim category of activities that would fit into that category. Okay. So what we're left with are official acts, acts that in some way, shape, or form are connected to the president's exercise of authority as president of the United States, whether that authority comes from a statute or from the Constitution, or just from the general understanding that has built up historically of what the president does. And the court here drew an important distinction between those things that a president does that are conclusively and preclusively in the president's authority, those that the Constitution makes the exclusive power of the president. Things like commander-in-chief power, the pardon power, the power to recognize foreign sovereigns, the power to remove executive officers from their official positions. For those acts related to the president's exclusive authority, the president has absolute immunity. So no matter what they do with respect to any of those conclusive and preclusive powers, they cannot be held criminally liable after they leave office, period. right? It's just a categorical immunity. Now, with respect to official acts that do not fall into that category of exclusive presidential control, all other things that a president might do that are related to being the president of the United States, the court sort of hedged and said, we're not quite ready to decide whether the president is entitled to absolute immunity for all official acts, although it doesn't preclude that possibility. Instead, what the court said is, at a minimum, the president is entitled to presumptive immunity, meaning they have immunity for all official acts unless, and I'll get the exact wording here, unless the prosecutor, the government, can show that a criminal prohibition to that act would pose no danger of intrusion on the authority and functions of the executive branch. Again, so that the court says this presumptive immunity doesn't apply to everything because it can be overcome. But if you take that wording seriously, right, it will pose no danger to prosecute the president to the intrusion on the authority and functions of the executive branch. I imagine we're talking about an exceedingly slim portion of activity that falls outside of that presumptive immunity. Never mind that it might actually, when the court reconsiders it, be absolute immunity. So I think a lot of people read this opinion as basically saying if the president is acting in an official capacity, then they effectively have, not completely true, doctrinally it's not quite true, but practically speaking, the president just about has absolute immunity from any criminal prosecution for those acts. Now, the court acknowledges the difficulty in separating official from unofficial acts, but what it does, the move it makes in sort of saying there are all these complications and figuring out whether the president is acting officially or unofficially, says that leads us to set the boundary very far out, to the outer perimeter of the president's official capacity. So it covers, in the court's words, all acts that are not manifestly or palpably beyond the president's authority. So unless the president is acting manifestly and palpably, that is, I think, obvious to any reasonable observer, that it is beyond the president's official authority, then we count it as official action, which again is, I think, effectively subject to absolute immunity. Last bit, which was controversial, where the majority sort of lost its sixth vote, Justice Barrett here peeled off. It was a 6-3 Republican-Democrat appointee split on everything that I've talked about up to this point. Justice Barrett peeled off and made it 5-4 with respect to a last point, which concerns the use of evidence. And the Supreme Court said, not only is the president immune in the ways that I've just described, but any evidence of immune conduct, even when it is in an indictment for unofficial acts, cannot be used. So the prosecution is disabled from using any evidence that might be gleaned from immune acts in order to prove to a jury criminal liability for unofficial acts. And Justice Barrett, in her sort of partial dissent, takes issue with that, doesn't think that there's any grounding for extending the immunity that far. So I think I'm still within my time, and that's a basic summary of what the court held in that opinion. So.
Thank you so much.
Absolutely.
And if you could pass it to Professor Serafin.
I shall. All the way over here.
Thank you. Set my own stopwatch. Okay. So thanks so much, everyone. Thank you for coming to the panel and including me. So I'm here to talk about the shadow docket. And the shadow docket is a term that first emerged in 2015 in an article by the common law scholar William Bode, and subsequently was popularized in a book, I think around 2019 or thereabout, by Stephen Laddick. So two very prominent common law scholars. William Bode, I think, is, like a bit more kind of, I guess I'd say center right, my sense is. Stephen Vladek's probably a little bit more center left. So these are people coming at the Supreme Court from, slightly different political orientations, but still very, very highly respected common law scholars. And the shadow docket, in short, is a way of describing how the court makes changes to the law, sometimes creates doctrine, in ways that aren't very obvious to the public. That's the sort of, I guess, shorthand way to think about it. So to back up a second, one thing I often say when I teach common law individual rights is to my students in that class is that there's an immediate sense in which you need to learn to read Supreme Court opinions for your job as a lawyer, to pass the exam, to pass the bar. Like, it's in your immediate practical interest. And these opinions often are not very clearly written. They're often, I emphasize this a lot, they don't follow the doctrine the way you think they should. It's a skill to be able to learn, interpret those opinions. But one thing I'll tell students as we get further into the semester is that beyond learning to read these opinions to serve your immediate practical interests, really what we're learning is how to interpret and understand an institution and how an institution operates and sort of how an institution wields power. I often tell my students that we're taking a sort of like sociological approach to understanding the court, right? And I think the reason why it's helpful to approach the court in that way as trying to understand how an institution wields power is that the shadow docket is this area of the court that it's very, very obscure. Often shadow docket decisions will come down literally like in the middle of the night. They're posted to these slightly obscure, like there's like one of like 4 or 5 different websites they could be posted to. They're often unsigned or have no opinions, no record of who voted for what. And they change the law in ways that are just not immediately apparent, but absolutely very, very impactful. And the reason why this is relevant to, the rule of law is that if you think about how you first learn Supreme Court decisions, or even before you came to law school, the kind of like potted account of the Supreme Court that you learn maybe in high school or maybe in college or even if you have no college degree, how kind of an ordinary person probably, if they have a rough sense of what the Supreme Court is and what the Supreme Court does, right? It's this highly stylized, formulaic presentation of arguments on either side of a certain legal question. While the court will stream audio recordings, while they don't allow cameras, there'll be sort of sketches of people appearing before the court, right? And then the court will sort of issue its opinion, and often these opinions are like, discussed and debated. And oftentimes, Supreme Court arguments and Supreme Court opinions are a vector through which the American public is kind of debating really important issues, right? So like in the lead up to Obergefell, right, gay marriage had been a huge aspect of public debate for, several decades. And the types of opinions that you see both at oral argument and then in the Obergefell opinion were like very common sort of arguments that you would see in public debate, right? So in a way, discussing legal arguments at court, before the court, and then in the opinions themselves are a way that the public kind of debates amongst itself, these important questions of political morality. And that understanding of, Supreme Court opinions as being, these sort of public texts has sometimes informed how the court itself will issue the opinions. So, for example, very famously in Brown, we haven't gotten to Brown versus Board of Education in my con law class yet, but I often ask my students, like, what, if you've never read Brown before, what's your immediate gut reaction? And Brown is kind of like in a way, a strangely written opinion. It's relative to the sort of enormous moral and political impact Brown has on American law and American society, right? Like the opinion is short. It's very relative to other Supreme Court opinions, kind of like written in simple prose. And the conventional history of the Brown opinion is that justices knew that their opinion was going to be just absolutely closely scrutinized and closely read and debated by members of the public. And they wanted an opinion that was short, easy to read, and easy to understand for members of the public so that the public would be more accepting of this vast change that Brown was going to make in American society. So, in other words, it's often argued among common scholars that there's a really close relationship between the court's legitimacy and the court's explaining its legal rulings, right? The court doesn't have any sort of authority to enforce its own opinions. It doesn't have control over the military. It has no real power over like the federal budget, right? What the court has is, what I like to think of as this sort of sprinkling of magic pixie dust that, people are willing to obey the court because they view the court itself as legitimate. And, that's partly why often, the court is concerned about its public standing and sort of public opinion about the court itself. Because if that magic fairy dust goes away and people think, oh, these, justices, they are not giving us principled reasons for why they are making this change to the law. They're just kind of effectuating their own political ends. Then the court starts to lose its legitimacy. And then this question arises of, are other institutional actors, are members of the public going to obey the court's rulings, right? And so part of the court's legitimacy and the willingness of other branches of government to enforce the court's orders is this perception that the court is not doing politics, the court is doing law, and that there's a sort of, maybe not an impermeable distinction between politics and law, but there's enough of a distinction such that we think the justices are doing something, that isn't just sort of like mere politics, right? This is part of the power of Justice Roberts' metaphor at his confirmation hearing, that what the justices are doing is they're like umpires calling balls and strikes, right? Sort of not engaging in the sort of competitive play of politics. And the shadow docket is kind of increasingly challenging the idea that the court is acting in a sort of good faith public manner. The shadow docket refers to areas of the court's authority where they can, say, overturn a lower court's orders or issue an injunction or decide on which cases they'll take up, in decisions that ultimately will have serious legal effect on the ground, but the decisions themselves don't feature oral argument. They often come without any sort of explanation of the reasoning. We don't often know who votes for what in these opinions, right? Hence the moniker shadow doctrine. These are, kind of unexplained orders. And so part of the criticism of the court's reliance on the shadow docket is that they are changing law in ways that it's very hard to understand as just a member of the public, right? And, that's perhaps undermines the court's kind of public legitimacy. The second criticism that is very common of what the court is doing on the shadow docket is that from kind of the first Trump administration forward, appeals to the court's shadow docket have expanded exponentially, and they have almost always been, largely resolved in favor of the Trump administration and sort of more politically right-leaning ends. So like one famous example of that comes during the pandemic. There's one case a case involving Governor Newsom and COVID restrictions on religious gatherings here in California, and the court declines to overturn COVID restrictions on religious gatherings. In subsequent cases during the pandemic, the court reverses itself and strikes down a number of restrictions on religious gatherings. Is it because there's a change in substantive law? Arguably not. Like, what happens in the interim? Well, Justice Ginsburg steps down, and Amy Coney Barrett and Brett Kavanaugh join the court, and it's a change in personnel, not really a change in substantive law. A second very famous use of the shadow docket comes with Texas's SB 8, and the court, long story short, before it overturns Roe and Casey and Dobbs, allows this measure to be enforced in Texas, which at the time was just like a flagrant violation of the rights of women to seek an abortion, but does so via the shadow docket in a sort of, unsigned, unexplained order. So, the worry is that relying on the shadow docket in this way, without public explanation, in ways that tend to lean to the political right, the court is kind of exercising a sort of political authority that it doesn't rightfully have. Thank you.
Thank you so much. And we'll pass it on now to Robin Tholin.
Hi, thank you, and thanks for having me. I'm here really to talk about one area in which we're seeing a lot of tension right now in the separation of powers, and also where some of these issues cash out, including the shadow docket. And that's with respect to the civil service and federal employees. This is an area that's being actively litigated, so I just want to say at the outset that I'm speaking for me and not any of my clients. This is obviously I'm going to be talking about some cases that are currently ongoing. So just for some background here, the civil service is a really interesting area in terms of separation of powers because it sits at the intersection of the executive and of the legislative branches. So federal agencies are executive agencies. They are within the executive. The president nominates heads of these agencies. They're confirmed by Congress. But one of the things that is really crucial is that these agencies are actually creatures of statute. So Congress has set up these agencies in statute. Congress provides directives in law for what the agencies should do and should be working on. Congress funds the agencies yearly in appropriations and for longer terms for certain work. And Congress has set out protections for civil servants. So there's a lot of different complicated, I'm not going to go into them, but protections for when you can fire civil servants, job protections for just the line employees. Generally, you can do large-scale reductions in force only in certain circumstances. Those are called RIFs. They require notice. They require a lot of procedural steps. There's a lot of different mechanisms by which people with more seniority can keep their jobs. This is all set out in statute. I'm not going to go into the history of this. Didn't think of it as very interesting, but apparently Netflix disagrees because you can watch all of the history of the Civil Service Reform Act in their recent miniseries about the death of James Garfield. So go and do that if you're interested. So this is the broader structure of how all of these agencies operate in general, and this applies to both the big agencies, the cabinet level agencies, Health and Human Services, Veterans Affairs, and a bunch of tiny agencies you've never heard of that have just a few people across the board. These are all working on a bunch of different areas. And in general, historically, the work of the line employees doesn't change that much administration to administration. So the executive sets priorities. They can affect, and the heads of the agencies can affect what the different agencies are really focused on. But your, National Park Service ranger, your VA nurse are going to be doing the same jobs no matter who's in power. And generally, that's been the case for a long time. There have been a number of attacks on the civil service in different ways, but what we've seen recently has been a huge divergence from the historical practice of the civil service. This current administration has made targeting the civil servants a particular goal, especially of the head of the Office of Management and Budget, and also back when DOJ was a purported agency. Both were really targeting the federal employees and getting federal employees to quit and trying to reduce the size of the federal government. And so a few different areas that we saw that in particular were starting last February. There was a purge of probationary employees. So in this case, OPM, the Office of Personnel Management, ordered all agencies to fire anyone who'd been in their positions for less than a year because they had fewer civil service protections. The statutes still required that those people could only be fired for performance or conduct. So OPM provided them, the agencies, a template letter that said everyone was being fired for performance. And then they terminated across the board, many agencies. At the same time, the president signed an executive order that was called Implementing the Department of Government Efficiency Workforce Optimization Initiative, great title, and that essentially ordered agencies to develop plans for large-scale reductions in force across the board. The scope of these was unprecedented. So the Department of Health and Human Services, for example, actually did issue the RIF notices under that executive order. They went to more than 10,000 employees, including people at the CDC, at FDA, at NIH. This included cutting CDC measles response teams that were dealing with active outbreaks. This included cutting the entire staff of a congressionally mandated black lung screening program. These were not terribly well designed, or they didn't spend time looking at what the actual congressional statutes were that they were required to carry out. And then there were also plans for more of these across agencies. So 65% of EPA was reported to be cut. The VA was targeting cuts to over 80,000 positions nationwide. This was all unprecedented. We represented a bunch of coalition of both federal labor unions and organizations and local governments that rely on federal services, who brought challenges to these cuts, both the probationary employees and the broader reorganization in separate cases. And both of them, we got preliminary injunctions stopping the federal government from firing the probationary employees, in fact, putting them back, and prohibiting any of these reorganizations and major cuts, both from district court judges. And so this is kind of an interesting place of when we were talking about where the separation of powers comes in. Both judges who issued these preliminary injunctions cited separation of powers principles and saw themselves as restoring the balance here between Congress and the executive. In particular, for the reorganization power, or the reorganization case, over the past many decades, 9 different administrations have decided to reorganize the federal government and done so by seeking authority from Congress. In fact, the first Trump administration, the president sought authority from Congress and it was denied. And he didn't do this entire reorganization. And so the judge in that case specifically ordered the agencies not to engage in these on a theory that this was overstepping the bounds of the executive and treading on Congress. Both of these preliminary injunctions were affirmed by the Ninth Circuit, and both of these preliminary injunctions were stayed by the Supreme Court on the shadow docket. The preliminary injunction, to give an example of the sort of lack of particular explanation, the language on the overall reorganization stay, which I will say came about 2 months after we got the PI, so the preliminary injunction was in effect prohibiting further cuts for about 2 months. But the reasoning was, because the government is likely to succeed on its argument that the executive order and memorandum are lawful, and because the other factors bearing on whether to grant or stay are satisfied, we grant the application. That's the entirety of the reasoning. There's no explanation of why they are lawful, but that's what the court did. But in that case, I will note that the court expressly did not rule on whether any particular agency's plan was lawful, which is still being litigated in that case going forward. Nor, as we would note, is that a conclusive determination that likely lawful does not mean lawful. We continue to litigate on all fronts in that case. I will just give one other piece from this whole saga, which is that the landscape changed in October when we had the federal government shutdown. The government continues to try to terminate all these employees. At that point, OMB issued a memorandum saying, well, because there's no funding to any of these agencies, that means that they are no longer congressionally mandated agencies. And so you should consider engaging in reductions in force of anyone who is doing work that is not the president's priority. That has absolutely no basis in law. A temporary lapse in funding is not the same as Congress saying that the agency shouldn't exist. We litigated that case as well. And on that one, the government came in fact, at the temporary restraining order stage, and just said, there's no jurisdiction here. This court doesn't have the authority to decide this issue for a lot of different reasons that are pretty complicated and I won't go into, but refused at oral argument to defend the legality of the memo. And just said, we don't have a position on whether this was legal. We just think that the court shouldn't be involved, which is a particularly extreme example of the executive trying to take authority for itself, not only over the legislature, but also over the judicial branch. The court said, no, I have authority, issued a preliminary injunction. In that case, actually, the government withdrew its appeal of that preliminary injunction. It never got to the Supreme Court. It was still in place and remains good law that, no, of course, they can't terminate federal employees just because they currently don't have funding that has yet to be appropriated.
Thank you so much, Robin. And we'll let Professor Sloss terminate or end up our presentation today.
Thank you. And I put together some PowerPoints here, so whoops, it's not right. Let's see. All right, so my topic is the unitary executive theory. So let me get this right here in a second. Okay. And the unitary executive theory is a theory that really first started developing within the Reagan Justice Department in the 1980s. And I think it explains a lot of what we're seeing going on here, particularly with the way the Supreme Court is handling the civil service cases that Ms. Tholin was talking about, and more broadly, things that are happening on the shadow docket. And so I want to first explain what the unitary executive theory is, and then say why I think it's fundamentally misguided. So the theory really takes off from a particular provision in the Constitution, Article 2, Section 1, that says, the executive power shall be vested in a president of the United States of America. That's the constitutional text. In a fairly famous case called Morrison v. Olson, Justice Scalia wrote a dissenting opinion and commenting on that particular constitutional text said, this does not mean some of the executive power, but all of the executive power. So the idea here is that this, what's called a vesting clause, gives the president personally the entire executive power of the federal government. Now, when he wrote that, he was a sole dissenter. He lost 7-1 in that case and on that issue. But despite the fact that his was a dissenting opinion in Morrison now almost 40 years ago, it's now the majority opinion on the Supreme Court. There are clearly 6 justices on the court who embrace this theory, even though Morrison v. Olson has never actually been overruled. So what are the implications here of the idea that the president has the entire executive power? Well, one important implication is the president has complete discretion to fire any executive branch employee for any reason at any time. And this goes to what the government is claiming in some of these civil service cases and some other cases as well. Secondly, and perhaps more importantly, that laws enacted by Congress that purport to limit the president's discretion in this regard are simply invalid. Okay, that goes against precedent that goes back to the 1930s, which has not yet been overruled but is soon to be overruled. And then more specifically, laws that create independent agencies are invalid insofar as Congress purports to give the heads of those agencies protection against what's called at-will removal. At-will removal meaning removal at the will of the president. And there are lots and lots of independent agencies out there that Congress has created that for various reasons Congress thinks it's important to insulate those agencies from presidential control by specifying conditions or restrictions on the president's power to remove the heads. And the court is in the process of sort of rewriting the doctrine here to carve out an exception for the Federal Reserve. Again, I'm talking about cases that are ongoing right now, but where this seems to be headed is, well, okay, Congress can protect the members of the Federal Reserve from at-will removal. Why? Well, because we, the court, think that independence of the Federal Reserve is important, but we don't accept Congress's judgment that independence of other agencies, like we're talking about 100 different agencies out there, is important, right? So they're willing to, stand up for independence of the Federal Reserve, but essentially no other federal agencies. Okay, so just to refer to a couple of cases that have come down on the shadow docket recently, Trump v. Wilcox decided on the shadow docket in May 2025. Trump fired members of the National Labor Relations Board, the Merit Systems Protection Board. In doing so, he was directly and very purposefully violating a federal statute that protected those people from being fired. The lower courts granted injunctions saying, we are going to enforce the statute against the government, and the Supreme Court granted emergency relief, stayed the lower court injunctions, and at least on an interim basis, none of these are final decisions, but on an interim basis allowed the Trump administration to essentially go ahead and violate this federal statute. Why? Because they think the federal statute is invalid because they buy the unitary executive theory. They didn't come out and quite say that, but that is, they gave very little explanation, but that's essentially the rationale here. Trump v. Slaughter, similarly, Trump fired a member of the Federal Trade Commission. Similar lineup here. Lower court said you can't do that. The statute protects them from at-will removal. The Supreme Court stayed the lower court injunction, said you can go ahead and fire them. What is different about this case is I referred to a case from the 1930s, Humphrey's Executor, where the Supreme Court specifically upheld protection against at-will removal for members of the Federal Trade Commission. That is a 90-year-old precedent that has never been overruled, and in this case decided on the shadow docket with virtually no explanation. The Supreme Court effectively says, well, we're going to overrule that case. We just haven't gotten around to it yet, so it's okay for the president to proceed as if we had overruled it and go ahead and act on that basis. That is effectively the rationale that the court lays out here. One agency that they haven't touched yet is the Federal Election Commission. I'll just say that there are a bunch of people making arguments right now about why the Federal Election Commission, it's really, really important to preserve independence of that. If we don't do that, we can end up with basically a group of Republican appointees overseeing federal elections to make sure the Republicans win elections, in effect, right? So at least some people are trying to hold out for independence of the Federal Election Commission. The court hasn't touched that yet. We'll see what happens there. Okay, this slide really talks about the civil service cases. I think I'm going to skip over these in the interest of time because Robin Tholin has already addressed those. So very briefly, what is wrong with this theory? On terms of the text, right? They read the text to say the executive power means all of the executive power, right? But that reading is really hard to sustain. Consider the other key provision that in Article 2 relating to the president. President has duty to take care that the laws be faithfully executed. Well, does that mean all the laws be faithfully executed? Not according to the unitary executive theory, right? According to the unitary executive theory, when the president is given the executive power, it's all of it. But when the president is given the duty to execute the laws enacted by Congress, well, it's not all of them. It's only the ones that we, the court, say are valid, right? Also, the Constitution gives Congress the power to enact laws to carry into execution powers vested in the president. This has always been understood to mean that Congress has the power to essentially decide how the executive branch is organized. The unitary executive theory, I would argue, is impossible to square with this grant of power to Congress that effectively grants power to Congress to decide how to organize the executive branch. Unitary executive theory goes against that. All right. I think I'm going to skip over stuff on the original understanding here in the interest of time again. And I'll just say in terms of practical consequences here. James Madison wrote in Federalist number 47, the accumulation of all powers, legislative, executive, and judiciary in the same hands may justly be pronounced the very definition of tyranny. Well, this is where the unitary executive theory is leading us. It is leading us to the accumulation of all powers in the president. The president gets to exercise effectively legislative, executive, and judicial powers, and it is contributing to the development of tyranny in this country. Finally, I would say we have a government that is there in principle to serve the public interest. But we have a president, right, President Trump, who has no desire to serve the public interest. And I brought along this New York Times from Sunday, this article from the Sunday New York Times, how the president has pocketed $1.4 billion to enrich himself from his operation of the presidency. This seems to be his main goal here. He's not interested in serving the public interest. He's interested in enriching himself and his family. And the court here, by removing checks on the president under the guise of this unitary executive theory, is becoming and has become an active accomplice in the destruction of Republican government in this country. So on that happy note, let's open it up to questions.
I think we have time for maybe like 10 minutes for questions. Let's see. Anybody have some questions?
So I messed up the slide.
Yes.
Hi. My question was about the shadow docket. Where did that practice come from? Like, where is the power coming from that they can do that? Is it in the Constitution? And has it always been this popular, or do certain courts use it more than others? And have the justices said anything about it? Just a couple questions.
Yeah, so a lot of what the court is doing derives ultimately from a law in the 1920s. It was colloquially referred to as the Judges Act, which grants the court certain authority to grant cert or deny cert, meaning, they'll decide to take away a case or not take a case. So to a large extent, how the court sort of structures its own docket and the powers that it has are results of congressional legislation. And in theory, could be changed by congressional legislation. And I think that's important to think about going forward, how Congress might be able to sort of rein in what the court is doing. And definitely some law scholars like Stephen Vladeck, who wrote the book on the shadow docket, have argued that that's precisely what Congress needs to do. I think one sort of broad theme that's running throughout this discussion today is the utter not just like sort of the ineffectiveness of Congress today, but its absolute abdication from holding the executive or the Supreme Court to any sort of meaningful challenge. I think, with the killing of Alexander Preddy in Minnesota last week, congressional Democrats and even some Republicans, I think, are starting to realize, how, I think really authoritarian the executive is becoming, and we might actually see a challenge to what ICE is carrying out. But generally speaking, the powers that the court is operating under are due to congressional legislation, could be changed through congressional legislation. And if I remember correctly, another one of your questions was like, is this something the court has always done? I think that's part of the critique of the shadow docket, is that it's just become like exponentially more sort of pronounced under the Trump administration, right? There were a lot of emergency appeals, like, especially like in the 1980s, of prisoners on death row appealing their imminent executions. So, it's been used in that regard. And there's definitely like, a case to be made that the court needs, part of the shadow docket is a very broad term, right? It describes also, like emergency applications, denials of cert, injunctions on lower court orders. And so, there are good justifications for all these things. Sometimes the court really does need to meet in an emergency. But I think if you look at the numbers and the way it has exponentially grown just in the last 5 to 10 years, and the way that it has grown in ways that almost uniformly favor the Trump administration, right, like, is where the sort of criticism of the court's legitimacy in using the shadow docket is really coming from. Sure.
So I think you mentioned other courts as well, and a question about other courts. And I want to just give a example of the fact that this isn't normal for other courts that also deal in emergencies. So in the cases that I was referencing, for example, we had a preliminary injunction granted by a district court saying the government can't execute RIFs, big reductions in force. The government's first move is to immediately appeal that to the Ninth Circuit and seek an emergency stay pending appeal, which is they want to overturn that injunction for the duration of the appeal. That's essentially the same posture that they eventually went to the Supreme Court on, seeking an emergency stay pending appeal. It's the same request to two different courts. And the Ninth Circuit didn't have oral argument because there wasn't time, but read the briefs and issued a fairly lengthy, involved opinion discussing all of the issues, going through the issues, and denying that on the standards that are at play in a stay. 4 different factors, it's a whole thing. But did a lengthy, reasoned opinion. The Supreme Court, in quite a lot more time, I would add, did not. And I think that is notable to say that the Supreme Court doesn't feel the need to give those reasoned opinions in a way that lower courts do, and often do at a very quick pace when necessary.
So just for comparison, I don't have the exact numbers, but these are pretty close. During the Bush administration and the Obama administration, so it's a period of 16 years, those two presidents sought emergency relief from the Supreme Court. This is like, cases on what's called the emergency docket, which is slightly different than the shadow docket, but same idea. They sought emergency relief from the Supreme Court a total of 8 times over 16 years, right? The Trump administration, Trump 2, right, in 1 year sought emergency relief from the Supreme Court 25 times in 1 year, right? So this has really exploded, right? The number of cases in which the government is seeking emergency relief from the Supreme Court has gone up dramatically in recent years.
We had a question from Professor Yang.
Actually,
I'm not sure who's
is
first.
it okay if I make a comment, actually, observation? I just wanted to make an observation, or just add that, with regard to the RIFs of federal agency employees, there's one particular agency, actually, that has been particularly affected, which is the Justice Department. That affects all of the litigation. And as you may have observed, of course, this president has essentially used the Justice Department as a political tool for prosecuting his political enemies. That would have been ordinarily very difficult because of the traditional barrier that institutionally the Justice Department has created between the White House and the Justice Department. That's essentially been erased at this point. And so what you see is really not only politically directed litigation, but also a lot of attorneys with the Justice Department leaving. That has affected, of course, all of these cases tremendously, including, of course, what is unheard of, essentially judges doubting and questioning the assertions, the factual assertions that have been made by the United States government. It's unheard of, I think. Usually the presumption is that the U.S. government, when you have a prosecutor, a U.S. government attorney, a DOJ attorney standing in court, making assertions, that those are verifiable, that those are absolutely true. And the courts are really, a lot of the lower courts essentially have come to the conclusion that you can't just rely on those kind of assertions anymore. It's just really a tremendous effect on the litigation and the operation of the courts, the federal courts.
So I think we maybe have time for one more quick question, because we're about at time. Yeah.
This kind of relates to how you were saying that the shadow dockets are kind of like delegitimizing like the power of the courts. DHS has like put out an internal memo that they don't need warrants anymore to go to people's houses. How are they able to do that? Are they going to do like a shadow docket, or are they just like essentially making their own laws?
So if the executive branch, we're in a situation right now where the executive branch, this is a bit of an overgeneralization, but doesn't really care what the law is. It doesn't feel constrained by the law, and therefore the MO is to simply do stuff and wait for litigants who are affected by unlawful behavior to bring lawsuits to try to stop it. And there are a variety of doctrines that make that very difficult. And